trying to protect a car source location at 59th and Sheridan Road from people damaging that property. He is among a group of people who have stationed themselves with open firearms, most of them carrying these type of AR-15 rifles openly slung around their shoulders. Many of them are on the ground, some are up on the roof. This is sending a message to anyone: stay away from this property, we are armed, you don't want to mess with us. And they essentially are successful in that assignment. That property is undamaged that evening. There comes a time, though, when the police use armored personnel carriers, Bearcats, and other armored vehicles to push all of the citizens that are out on the streets south of that location. Police establish a barrier at 60th and Sheridan, and essentially everyone is moved south of that and can't get back to 59th. So this car source location, they've now successfully protected, and everyone's gone. So there's no one to threaten this building anymore. However, prior to the police establishing that cordon line at 60th, the defendant and another armed individual, part of this group, go down to 63rd and Sheridan, to the other car source location, because they hear whoever was supposed to guard that location is no longer there anymore, and we need to go down there and check it out, maybe protect it. So they go down there, and at some point they try and come back, only they can't get back because the cops have blocked off 60th and Sheridan. So now the defendant is trapped on the other side of that line. He's trapped with this other individual. He can't get back to the rest of his group. His job that night is to protect 59th and Sheridan. He can't do that job anymore. So what does he do at that point? Does he go home? Does he say, okay, it's 11:30 at night, my job is done, I'm gonna get out of here? No. He takes it upon himself to run around in a hostile crowd, a lawless situation, a chaotic situation, with people who have guns, people of varying motivations. He's openly carrying an AR-15 or a Smith & Wesson M&P 15 assault rifle type weapon. He's running around and he's trying to stop people from doing things because he thinks what they're doing is illegal. And maybe it is, maybe it isn't. But at some point during this interaction, he gets into a confrontation with Mr. Rosenbaum and is essentially trying to stop Mr. Rosenbaum from doing what Mr. Rosenbaum's doing. Now, that's not Mr. Rittenhouse's job. He's 17. He's not a law enforcement officer. He's not deputized. He's got no training. But he takes it upon himself to take the law into his own hands to confront Mr. Rosenbaum because he thinks Mr. Rosenbaum is doing things he shouldn't do. And this fire extinguisher that he's carrying it along, pursuing Mr. Rosenbaum with the intent of stopping Mr. Rosenbaum from doing whatever he was going to do. And that's what leads to that confrontation. The similarity between August 10th and August 25th is in both situations, the defendant took the law into his own hands, or talked about taking the law into his own hands with the same gun to stop things that he thought were going on, that he didn't think should be going on, and he appointed himself a vigilante, taking the law into his own hands in those circumstances. They are identical in that respect. And when we talk about the defendant's motive and intent that night, this is crucial to the case because that is exactly what he's going on. And the defense will have testimony on this. They will say, Mr. Rittenhouse was trying to stop these people. He was concerned about looters. He was concerned about fires. He's going to put them out with the fire extinguisher. He's going to stop these bad people from doing bad things, or so he says. Except that that's not his job. Nobody asked him to do that. He's got no legal authority to do that. His job was done. 59th and Sheridan was no longer in any danger. Go home. But he didn't. He was isolated. He was cut off from the rest of his crew. He was running around with an assault rifle type weapon, a very threatening, aggressive weapon, one that deters people. It is designed to deter people. It is designed to threaten others, to let them know, don't mess with me, look what I've got. Other people that night are carrying around semi-automatic pistols, Glocks, which you can conceal and hide. Other people can't see it. It's not designed to tell people, go away. It's not designed to tell people, leave me alone. You carry around an assault rifle like this, you're sending that message to other people. That's what the defendant was doing. Running around in all this, taking on this responsibility, which he had no lawful authority to do, and making assumptions about what Mr. Rosenbaum was going to do next, or what he shouldn't have been doing, and then confronting Mr. Rosenbaum about that. That is the context here, Your Honor. And the August 10th incident is exactly the same in that respect. exactly the same and taking the law into his own hands with the same gun, making assumptions about what other people are doing, and taking responsibility to try and stop people when you are not trained, you're not a law enforcement, you're a teenager. Not his job. So it's exactly the same fact scenario, Your Honor. And I apologize for not making this clearer in my motion, but I think when you look at it through that perspective, Your Honor, you can see why this goes exactly to motive and intent. Now, you say it's proclivity evidence, it's propensity evidence. It shows a motive and intent to be a vigilante that night and take the law in his own hands and use deadly force to stop people who are committing crimes that no one is allowed to use deadly force to stop. Police officers are not allowed to shoot shoplifters. Police officers are not allowed to shoot people who are about to set a vehicle in a used car lot on fire. You don't get to use deadly force in those circumstances. You don't get to threaten deadly force in those circumstances. So what Mr. Rittenhouse was doing was well beyond what even the police could have done that night. He took it upon himself, and that is unlawful. It is unjustified. That's what we're talking about here. So that's the exact similarity between those, and that's why the state's asking that the court allow the jury to hear this, because it goes to his state of mind. It shows that he is the type of person who will act to take the law into his own hands. The defense will give their side of the story. They will portray the defendant as this altruistic young kid who came here to try and help. The jury can make the decision. But let's
real quick, YouTube chat is shut off.
Whole picture here. And they can make a decision.
Go to PTNN if you want to chat. I can't have anyone type something stupid and get me banned today.
The jury can make a
so
decision
YouTube chat is off.
What the intent and motive of the defendant was, what his subjective beliefs were, and whether or not they were reasonable. But this information is crucial to the jury being able to make that decision. And they deserve to hear it, along with everything else that's going to be submitted by the defense that's going to portray the defendant in a rosy, innocent, altruistic light. Let's have the full picture here. That's all I'm asking.
So, Judge, I was unaware that Mr. Rittenhouse actually called the authorities on the August 10th date. And I do think that further supports the idea that that evidence would not be admissible. And the reason I say that is the state's position to you in their written motion now becomes further from reality. When they say the video demonstrates he was eager to use deadly force, not only did he not use it, but as you said, he called the proper authorities. He did what anybody in this room would say you should do if you believe something unlawful is happening. To a T. He didn't threaten anyone because no one who was apparently looting or whatever they were doing was aware of him. The real difficulty I'm having in accepting Mr. Binger's statements are, if we're going to be honest about this, it is not debatable that Kyle Rittenhouse is running to put out a fire. If you're telling me that he is now inserting himself into an unlawful position, we encourage people. I would argue that we would encourage people to put out fires.
But I'm not clear, listening to Mr. Binger, whether he was disagreeing with the statement that the accused was moving towards putting the fire out, or whether he just said he should have gone home. Are you claiming that he was not attempting to use the extinguisher to put out the fire, or intending to do so?
What I'm saying is that in the circumstances before the ultimate confrontation between the defendant and Mr. Rosenbaum, that Mr. Rittenhouse was pursuing Mr. Rosenbaum. Mr. Rosenbaum had not, in fact, done anything. They hadn't even gotten to the 63rd and Sheridan Road car source location. Mr. Rittenhouse had a fire extinguisher. He was carrying it along, pursuing Mr. Rosenbaum, and I believe that he was assuming...
Wait a minute. I thought I heard the first version by the defense was that Mr. Rosenbaum was pursuing the accused, and that the accused had the fire extinguisher. What is it?
Your Honor, our client leaves from 60th and Sheridan with a fire extinguisher. He runs or trots down Sheridan Road, passing Mr. Rosenbaum. This is all on video. There is no interaction between my client and Mr. Rosenbaum. Then Mr. Rosenbaum gives chase, and it's in the video where Kyle drops the fire extinguisher right as he enters the lot of car source number 3, with Mr. Rosenbaum in hot pursuit of my client. There's nothing on the tape, any tape I've seen. If they have something I haven't seen, I'd love to see it, where he has any interaction with Mr. Rosenbaum. And the state says that he was down there earlier with Mr. Balch. I don't know when they're talking about, but when he left the 59th Street car source and went down, the whole thing is on video. He goes to that parking lot, which would be the southwest corner of 60th and Sheridan. There's somebody who confronts Kyle, and he walks away from them, goes over to the gas station. That's where the call comes in. He's never down to the 63rd Street car source. He never has any interaction with Mr. Rosenbaum until Mr. Rosenbaum gives chase to Kyle. That's all on video.
That is actually not, and I'll submit that Mr. Richards is right. He hasn't seen what I'm referring to, although he's got access to it. But on this particular evening, the FBI had a fixed-wing aircraft hovering above Kenosha. We have the footage from that. Counsel can obtain it from Joint Services. I emailed Counsel a few weeks ago and let him know about it.
Yesterday.
What it shows...
Yesterday.
No, I can pull up the email, Mark. I emailed you several weeks ago and let you know about it. The video is an infrared video, and what it shows is that...
Let's get settled when you send it to him.
I haven't received it yet. We're picking out it after today's hearing.
But I mean, when were you notified that it's available?
I emailed Mr. Richards on September 3rd.
Okay. Go ahead.
What that footage shows, and it's an infrared video because this is nighttime, so infrared is the best way to capture what's going on. What it shows is Mr. Rosenbaum running south towards the 63rd Street car source location. Behind him, probably 20 to 30 feet, is the defendant. Mr. Rosenbaum, upon reaching that location, immediately runs near a parked car. Mr. Rittenhouse follows him, runs to the other side of that parked car, and appears to turn and confront Mr. Rosenbaum. I will note that where Mr. Rittenhouse stops near that parked car is exactly where that fire extinguisher is later found, okay? So, Mr. Rosenbaum hadn't even gotten to that car source yet. Hadn't had the opportunity to do anything, hadn't done any fires, done any property damage, did nothing. Mr. Rittenhouse is following him with the fire extinguisher, probably because he thinks Mr. Rosenbaum is going to do something. But Mr. Rosenbaum never does. What happens is when they arrive at the car source location, Mr. Rittenhouse turns and confronts Mr. Rosenbaum from across this parked car, says something to him. And of course, we can't see, it's a video from an airplane, so we don't know what happened, but we know immediately upon that confrontation, Mr. Rosenbaum then runs around behind the parked car, and the chase starts at that point in the parking lot. But prior to that, Mr. Rosenbaum was running first, Mr. Rittenhouse was running after him. And I would note, he's running after him with an AR-15 rifle, openly displayed. And Mr. Rosenbaum at no time has a weapon in this entire incident. We know this because obviously...
Look at the defense attorney, the bald guy. He is so pissed.
He never had a weapon at any point. So Mr. Rosenbaum is being chased by an armed individual who is assuming Mr. Rosenbaum is going to do something wrong and wants to stop him, and does in fact confront Mr. Rosenbaum at that parking lot.
And the FBI,
and the FBI
had a plane
that we didn't previously have.
Fixed wing up in the air. Wow.
Mr. Rosenbaum then circled the car, and then the chase began. And who's chasing whom?
At that point, then Mr. Rosenbaum goes around behind the car, starts to chase Mr. Rittenhouse. They run into the street briefly, then cut across the car source parking lot. It's at that point that Mr. Rosenbaum throws that plastic bag towards Mr. Rittenhouse. They then run in between some parked cars, and Mr. Rittenhouse shoots and kills Mr. Rosenbaum.
Well, I still think they're dissimilar incidents. I think that I don't think that they're going to be helpful to the jury in deciding whether the actions of the accused constituted lawful self-defense. the events are so totally dissimilar, and it comes down to proclivity. That's not the word I want. But propensity. Thank you. Propensity evidence to show that he's a violent vigilante, and he's going to act in accordance with what a violent vigilante will do. And the incidents are so dissimilar. It seems to me that, but on this one, I think I'm going to withhold a final decision with a bias towards refusing the receipt of the evidence. And so we can talk about this further at the time of the trial when I've heard more, and perhaps seen some of the footage that you lawyers have been talking about, so I have a more complete understanding. But at this point, if I had to make a decision, and I don't, because this is admissibility, I would deny this admission of this evidence. There's a motion to dismiss count 6, to which the state has not responded, that I saw anyway.
You're right, I have not. I didn't. The issue has come up, and I have responded in the Dominic Black case, which is a identical legal issue, and I filed with the court a brief in that case. But essentially, the law is clear that there's a blanket prohibition on possession of a firearm by anyone under the age of 18. There are exceptions to that, and those exceptions are very narrow. They do not apply to this case. And I think really what the defense motion is arguing is that somehow it's the state's burden to disprove that those exceptions apply. I disagree with that. I think those exceptions are essentially affirmative defenses. If the defense, and the only one we're talking about here is these hunting statutes, which are Wisconsin statute section 29.304 and 29.593. There is no evidence in any way, shape, or form that the defendant was in compliance with those. This is not a situation where a 16-year-old was out deer hunting with his father, for example, which is what those exceptions are intended to cover. So there's, like I said, a blanket prohibition that a minor may not possess a firearm like this, and that's really the end of the court's inquiry, as far as I'm concerned.
All right. I know I'm not going to take further argument. I want to read his brief first.
Can we get a copy of that, Judge?
Yes. File a copy of that. I also have the Black case, and I haven't been called upon to make a decision. I think it was on for the counter, got bumped due to a jury trial or something. So I believe I've read that brief before, but I certainly want to read it again, and I certainly want you to have the opportunity to see it. So I'll take that one under advisement also. Next issue is, well, let me ask you about this. Are we ready for the November 1st trial date?
Yes, I believe so.
I believe so.
Okay. Next issue is, it would be my inclination to have the voir dire conducted. I was originally thinking 80 to 100 potential jurors, and I was talking with another judge the other day and mentioned that, and he seemed alarmed, and I think, well, you know, I don't want to shave too closely, so I maybe will bring in more. Maybe I'll bring in 150. I'm not committing to that, but there'll be a large number, larger than could be accommodated in this room. We obviously need to save some seating in the room for the families of those whose lives were lost and for the injured party, and for the family of the accused. And some additional seating, and then there's court personnel and the security and the like. So I'm going to guess. Do you know how many we've sat in here at maximum? I thought it was 95 or something. Yeah, so around 60 maybe we could get jurors in here. So my inclination would be, if there's no objection, is to have the have the voir dire conducted in the normal way here in the courtroom with the numbers over, I would probably pick maybe 4 to 6 additional jurors. And then have we'd have about 60 to work with, maybe we can get as high as 70 or 80. We'd work with those here in the courtroom, and that I would have the proceedings televised down to the jury assembly, which can hold a much larger number, and they would be instructed to watch what was happening here, just as they were if they were in the room, and that they're to make a mental note of any to which they would raise their hand. And then if they're called upon to replace a juror, they would be asked, would you have raised your hand, and if so, which questions? As if they had been in the courtroom, except that they would actually be participating over the miracles of television. Does anyone have objection to doing it that way?
No, Your Honor.
I have a problem with that. Would there be a bailiff or somebody monitoring?
Oh, sure. Okay. There'll be, believe me, there'll be plenty of precautions to make sure there aren't any problems. But, okay, that was, I don't think there's actually a right to have it done all in one room, but I wanted to clear it with you folks anyway. The other thing is, I looked at your jury and your proposed questionnaires, which were very good. There were certainly some areas that I did not want to embrace. And I will also tell you that I suspect, due to my age and my longevity, that I maybe have tried more murder cases than anyone in the state. And I've never used a jury questionnaire that I can recall before. And if I did, it was only in a moment of weakness. There are a variety of reasons I'm not crazy about submitting a jury questionnaire. First off, I will tell you that when I do the voir dire, and I do have fairly restrictive views about what's admissible questions. There were some, for example, asking people about support for political groups or protest groups or whatever, that I would probably consider off limits, in spite of the fact that there is an aspect of that to this case. I would most probably not permit questions about whether people support a political belief about gun ownership, for example, or gun possession, or membership in particular organizations, unless it's shown to be directly relevant to this case. This is not a political trial. It's not going to be a political trial. I certainly allow reasonable questions that might suggest a witness would be biased one way or another, and that may at times get into some of these areas. But as we know, a political vote is inadmissible under all circumstances, to ask somebody how you voted in the last election or something like that. And whether you made a donation to a political group, I think falls pretty much in the same category. But I don't want to be too blunt about that, because there are aspects to that that could be a legitimate issue. And the other thing, another reason why I'm not crazy about questionnaires, is they're going to forewarn all kinds of people that they're being considered for this particular case. And as somebody referred to earlier on, there's people all over town who are talking about this case. And I have had One person asked me in the grocery store, didn't ask, the person said, I would like to be on the Rittenhouse trial, and I will disclose the identity of that person to you folks. And of course, that person will not be on the Rittenhouse trial. But there are other people, you can tell that they're just itching to talk about it, and they talk about it a lot. And I also had a conversation with someone from the Kenosha News, because there have been 2 letters published in the paper, which I thought was very irresponsible, that dealt with what the outcome of the case should be by people who have not heard any evidence. And when people in the past have asked me about a case, and it happens rarely, I have always told them, when they tell me how the case is going to end up, or how the case should end up, I always tell them, you've got me at a disadvantage because I haven't heard the evidence yet. And I'm, in a way, I'm insulting them, and I'm hoping that they understand why they're being insulted, because they don't know. And the letter writers that got published had no business writing those letters, but shame on the media that publishes that, and I hope that's not going to happen again. But, and there's been some grossly irresponsible misreporting on a few occasions about what happened in this case, and the case has been politicized, as we all know. The questionnaire is only going to get those people who get the questionnaires talking about it. They're told, don't talk about it, but we're always cautious about that. And when I conduct these trials, in some cases that you'd recognize the names, I usually make I have a little discussion about the Bill of Rights, and about which includes the right of the media and the price we pay for having a free media, which is a lot of inaccurate reporting, not because anybody's particularly sloppy, but because of the pressures that they have and the need to get the story out and the lack of ability to cross-examine and all the other features. And educating them about how the media, responsible media people themselves would agree that the cases should not be tried in the media. So, and then, only then ask them, have you read or heard anything about the case? And I find that very, very rarely does anyone who has read or heard anything about the case state that he or she is unable to put that all aside. And that's what I would expect to do in this case. And I also, there's a line in one of the submissions that says the jury won't be sequestered. That is certainly not my intent. But when we have the jury here, I am going to warn them about that possibility, because I don't want to get halfway through the trial and then tell them, guess what? So I would tell them that certainly that is not, I haven't sequestered juries since it became lawful to try them without sequestration, so I wouldn't expect this one to be sequestered. But I'm not going to tell them they won't be, because it's possible that they could be. But the bottom line is, I feel fairly comfortable that we can get a jury selected in a reasonable time, in a day's time. If we have all the jurors, we won't do it in panels. We'll have
he said he could do it in a day? Yeah, right.
Or by video. So we won't have to repeat anything, hopefully. And you can follow through on your questions. But that's my thinking, and I invite your reaction, negative or otherwise.
Your Honor, I think the parties are in agreement that a questionnaire is necessary in this case. I don't want to speak for counsel, but I know they've submitted their own questionnaire, and I know that we had discussed this at a prior hearing and I think we'd both taken the position that it was appropriate, and the court had invited us to submit them. So I thought we'd kind of dealt with this already, but I will address it again. I respect the court's experience in trying homicide cases, and I'm well aware of that. I think we can all acknowledge that this is one of the highest profile cases in Kenosha's history. It is one that the events of these nights affected our community in a widespread impact, independent of anything the defendant did. The shooting of Jacob Blake and the subsequent nights of protests and riots and property destruction had affected a huge swath of our community. And so there's not going to be a lot of people out there that haven't heard about it and haven't formed some impressions one way or the other about what happened to Jacob Blake, about what happened to our community, about the various political or philosophical movements that showed up here in response to all of that. It's probably oversimplifying it to say that most people fall on one side or the other of the spectrum, but certainly a large percentage of our population feel strongly one way or the other. There are clearly some that are not invested or don't have an opinion or whatever the case may be, but I think it's fair to say that this is an issue that is a polarizing one, these events, and they've crystallized around the defendant. There are some portion of the population that, for the way they see the world, his actions fit and are justified, and there's some portion of the population who see the world and his actions are unjustified. And I agree with the court. I'm not here to argue any of that. I'm concerned about what the law says. I'm concerned about justice in our criminal system here, and I believe that our charges against the defendant are appropriate, and I think that we will prove him guilty. But I don't need to get into a debate about the political movements or about Jacob Blake or about any of that stuff. But it would be, I think, naive for us to ignore the fact that the 100 or 150 people that you bring into this courtroom are all, not all, but most of them are going to have opinions and knowledge. And a jury questionnaire is important to help the parties make our important decision in this case with enough time and to deliberate and to evaluate, to investigate, and to make a decision about those jurors. In the heat of the moment in voir dire, we may have a juror who doesn't answer a single question, who doesn't raise their hand. We've all seen that happen, where there's a member of the panel who never responded in any way to anything. And we don't really know at that point. We've got a little bit of information, maybe we've got a name or an address or an occupation, but other than that, we don't get a lot. If this were a misdemeanor retail theft, I can live with that. But the stakes obviously here are much different. So I believe that a jury questionnaire is important, and I would urge the court to finalize it, and I think it's important that we get it out the door with enough time to give the jurors an opportunity to fully respond to it, because both of these submissions are 10, 15, 20 pages in length. It's going to take some time, and then it's going to take time to get back to us, and of course time for the parties to review that and the court to review those, to make some evaluations of those individuals. But I see this as a unique situation in which this is important information that we're going to need in advance. We have set aside a couple weeks for this trial. I don't know if that's going to be enough time or not. We'll see. But I agree with the court that we want to try and do voir dire as quickly and efficiently as possible, and a questionnaire is going to be incredibly helpful in that process. I understand the court's concern that we're tipping off potential jurors, that this is the case they're being called on, but that's inevitable. They show up on Monday morning, they're going to know. They're going to see it very quickly. I do believe, however, that no matter what we do here, it's important that we protect the jurors' confidentiality, we protect their safety, and I know we've had some discussions about that, but one of the things I wanted to bring up is during voir dire and during this entire process, I think it's important that we refer to the jurors only by number and not by name, because I think there is a serious risk in this case that if their identities become published, in today's day and age, the internet is the bane of our existence in the sense that anybody can put anything out there, home addresses, phone numbers, family members, etc. It makes jurors particularly vulnerable in today's day and age. So I think that no matter what we do, we need to make sure that we only refer to them by number in open court. Thank you.
Thank you.
Judge, so one of my last trials, we used jury questionnaires. While Mr. Binger's right, it's helpful to the lawyers, and I agree with him on getting them, by the way. What it was, though, was enormously helpful to the court. And the reason it was helpful to the court was everybody had heard about that case like everybody will have heard about this case. And the people with the strong positions on the case have provided that to you and to the parties in writing, and what they weren't able to do was poison the entire panel by saying, I've heard about the case, I think X or Y about this case. So people who had strong opinions, we were aware of it ahead of time. The judge was able to, if she needed to in that case, to do individual voir dire on those people, so they didn't poison, in this case, 150 people about what was going on. That's what was really helpful in a case where everyone's going to have heard about it, so when you ask that question, every hand will go up. I would submit to you the majority of people have an opinion one way or another. And what I found to be really helpful, and that was Judge Ryder on a case where we were able to separate those people out pretty quickly, and she was able to ask them, would you be able to set this aside? Would you be able to do this? Without having to worry about their statements influencing other jurors, if they had heard things about the case, talking about those things that they had heard, which clearly wasn't evidence at that point, right? So I think everybody in that case found it useful. That's the reason that we had suggested it here, because I don't think the type of case matters as much as the publicity behind it and the strong feelings one way or another. So I agree with Mr. Binger that I think it's appropriate because I think it'll help you at the end of the day. I think it'll help us to make sure we're not poisoning people. I don't know if you want to address the issue regarding anonymous jurors. I'm only really here to talk about the jury questionnaire thing, but I think at the end of the day, you would find it to be, you might not have used it, but I think you would find it to be useful in trying to make sure that you do get an impartial and fair panel.
All right, well, let me take a look at it. I've given you my thoughts. I've heard what you have to say, and I don't want to grab control of the case away from you guys. Let me think about it, and I'll make a decision by Monday or Tuesday. And then if that's done, then you'll get a composite of what I think are acceptable questions. So there's some that I'm not even going to go into right now. And we can discuss later if you feel that you disagree with the decisions I make. Anything else today?
We were going to set a date for the Daubert.
Date for the Daubert. I would guess so.
Judge, with regard to the Daubert motion, the witnesses that are proposed as experts, could they appear by Zoom?
Yes.
Thank you.
What time we thinking? If we could do like 10, I've got a point right here. 30.
All right. Anything else today?
That's fine. Does that work for you?
Okay. Thank you very much.
Thank you, Your Honor.
All right, thank you.
Well, I think it's kind of weird. A couple of things to take away from there. This judge, especially after watching the Derek Chauvin murder trial, this judge believes that he's going to get the whole jury seated in one day. That doesn't make any sense. because that's not going to happen. There's absolutely no way that they're going to be able to find a neutral jury in Lake County, which is the same county of Kenosha. There's no way. No way at all. So I know a lot of people were probably ticked off that the YouTube chat was turned off and Facebook was on supporter only. We are trying to preserve our platform, and, well, this is a very touchy subject. I mean, here's something. Go look. Here's what I did in order to find this video, because we missed the beginning of it. In order to find the video, I had to search forever to find it. Finally found it on the court page. But if you typed in Kyle R, his full name, on Facebook and click live, even though there are live videos showing, it did not show up. They have a complete and utter block on it. So I had to take some steps to make sure that we protect our platform. What I will do is I will be showing his entire trial, as long as they're broadcasting, which I believe they are. I'll show his entire trial, but I likely won't do it on social media. I'll just do it for free for everybody with the embedded chat on PTNN somewhere. But yeah. You know. I'm going to have a show, Wake Up America, tonight, where I'm going to talk about how our country sucks. And plus, I'd like to give a special shout out to a kid named Wyatt. F you. Okay? I censored it. But Adam knows why. F you, Wyatt. Okay? F you. Plus, I told the principal at my kid's school that my son has permission to punch a kid in the face if he's being bullied. The principal's like, sometimes, that's just what you got to do. So we'll see. I bet Wyatt's no longer thinking he's a tough kid. Anyway, I'm going to wrap this up. I appreciate it. Someone said no sound. Yeah, well, there is. Unmute yourself. But I'll be live tonight, 7 o'clock. Also, starting next week, my show is going to be bumped up to 8 o'clock p.m. We're going to be doing it differently. It's going to be 5 days a week, Monday through Friday, 8 to 10. It's going to be a produced thing. We got to figure out all the details. But I think Adam's going to do a couple of shows during the week, probably during the day. But my show will be from 8 to 10, Monday through Friday. Well, it's gonna be different. You're gonna like it, and that'll be the regular podcast. None of this gaming shit. I'll do the gaming stuff during the day, like right now. I'm gonna be on Twitch in about 5 minutes, and we'll be there. But F you, Wyatt. Okay, Wyatt, you little punk. You don't want to mess with an Oatly because we'll punch you right in the face. Anyway, we'll see you later. Bye.